HMV. I take great pleasure in welcoming you all to the sixth session of our FDP. The focus of this session, regulation of cyberspace, is of great importance in the present digital era. As teaching, research, governance, and communication increasingly move online, the need for clear framework, policies, and safeguards in cyberspace cannot be overstated. We are truly privileged to have with us Dr. Manoj Kumar Sharma, Associate Professor at Rajiv Gandhi National University of Law, as today's distinguished resource person. He is an eminent expert in the field of law. He has 21 years of teaching experience. He has authored and edited various books, published 22 book chapters, 35 research papers, and developed MOOCs course for UGC. He organized various conferences and attended various workshops, training programs. With his rich expertise, Dr. Kumar will enlighten us on how cyberspace can be effectively regulated to balance innovation, security, and rights, a theme that holds immense significance for educators, researchers, and policymakers alike. On behalf of the organizers and participants, I extend a very warm welcome to Dr. Kumar and invite him to lead us through today's session. Sir, the screen is yours now.
Thank you so much, madam. Thank you so much. So I was scrolling through the data for the digital India and see how much is the cyberspace in India, what is the volume of cyberspace in India, and found that in India we have 1.12 billion cell phone connections which are active in Feb 2025. And of these, we have 806 million, approximately 80 crore people who are using the internet in Feb 2025, which is expected to rise up to 90 crores, 900 odd millions by the end of 2025. Of these, 491 million users were using social media in January 2025. This is the data from Data Reporter of their digital 2025 India report. When I visited statista.com, I found that in the world over, 5.56 billion individuals, they are using internet services. That is almost 68% of the global population. And the majority of them, they were having access to the social media and they were using the social media. And it is, so you see how gigantic is the cyberspace. And if we see the digital economy, you find that I went through this United Nations Trade and Development Report, Digital Economy Report of 2024. And the report says that digital economy is booming. So far as the mobile phones are concerned, they have shipments of mobile phones have doubled from 2010. And now in 2023, 1.2 billion mobile phones are shipped annually. And if we see the Internet of Things, the IoT devices are projected to surge 2.5 times from 2023 to 2029 to reach around 39 billion. So you see, whether it is e-commerce, whether it is the access to social sites, whether it is access to mobile network or internet usage, the digital use is growing. The e-commerce sales have grown almost 60% from 2016 to 2022 to reach $27 trillion as per the United Nations Commission on Trade and Development report of 2024. Now, that being the scenario, IBM Security Data Breach Report of 2024 states that in India, the data breaches, cybersecurity challenges are humongous. And the data breach cost in India has increased. It has reached a record high of 17.5 crores, and which is increasing at around 6.6% from 2021. And if you compare it with 2020, the increase is around 25%. There are lakhs of cybersecurity incidents which are reported annually or in the online portal. And for example, we see that the airline Air India data was leaked 4.5 million customer data was leaked. There are reports of Aadhaar data leak. So therefore, if you see, there is huge cybersecurity challenge which we are facing, and it is in this context that we have to understand the cybersecurity and the regulation of cyberspace. So therefore, keeping that in mind, the international community, including India, started making efforts to regulate the cyberspace, because cyberspace regulation is much different from the regulation of the traditional crimes, the regulation of offenses and other torts which are committed in the offline mode, as we can say, which culminated in various international documents, be it United Nations Convention on International Trade-related Aspects, UNCTAD Model Code, be it the Convention on Cybercrime, Budapest Convention, be it European Union e-commerce directives, or G8 countries high-tech crime working group. So many efforts are made. I'll not detail into them. So far as Indian law is concerned, the slide is moving or not? Let us hope it works now. Against a popular misconception that cyber law was enacted only in the 21st century, that is the Information Technology Act, the legal experts claim that the first attempt to regulate the information technology took place in the year 1885 in India, when the Britishers enacted Indian Telegraph Act of 1885 to regulate the usage of telegraph, telegrams, and telephone in India. So that was primarily the first attempt in India to regulate the information technology, and which later on, of course, we understand the primary act to regulate the cyberspace came in the 21st century when the Parliament of India enacted Information Technology Act, under which we have formulated various rules. I will not discuss them for the time being. We understand that Parliament has recently also enacted another specific legislation for dealing with online gaming, that is Online Gaming Act of 2025. Yesterday, we referred to Digital Personal Data Protection Act of 2023, another law for regulating the data protection in the cyber world. And then in 2023, India came up with three new criminal laws: Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Sakshya Adhiniyam of 2023. All of them are partly managing, regulating the cyberspace and the offenses committed in the cyberspace. It is claimed that the first recorded cybercrime happened in 1820. Have you any guesses? I'm not saying it is a typical cybercrime, but then it is claimed that the first recorded cybercrime took place in France in 1820. Though it was a sabotage sort of a thing, but then that can be correlated with use of information technology and the IT or the information technology, the offenses with the use of or with the against the information technology. Any guesses? Anyone? You can Google it. Okay, if nobody is responding. So in 1820, the French textile manufacturer Sir Joseph Mary Jacquard, he created an automated room, and there was fear among the employees that it will eat up their employment, it will eat up their livelihood. And since the device was latest technological advancement, and it was blended, the device was blended with analogical technology in the weaving of special fabrics, the employees committed the act of sabotage so that Sir Joseph Mary Jacquard could not use this new technology because they thought that it is posing a danger to their employment. This is claimed to be the first ever act of crime against technology. Anyways, this is just the data. Now coming to the Indian position. So far as India is concerned, as I said, India has enacted Information Technology Act and host of other laws. So far as the Information Technology Act is concerned, Information Technology Act, if you see the intention of the act, it is intended to be a comprehensive law for dealing with varied aspects of information technology, including the recognition of information technology, recognition of e-commerce, regulation of e-commerce, prescribing administrative setup for regulation of e-commerce, for regulation of electronic signatures, digital signatures, regulation of online content, data processing, and also to create a system for defining offenses with the use of technology, with the use of IT devices, and offenses against the IT devices. So if you see, this act was intended to provide legal recognition for e-commerce transactions, because once in 1997 United Nations Convention, or so far as the international trade related aspects, they signed a model code, UNCITRAL code on electronic commerce or e-commerce, and India being a signatory was bound to enact a law in India for regulating the electronic commerce, and therefore primarily the act was enacted with the motto of recognizing electronic documents, recognizing electronic documents as a mode of effecting contracts, and also to understand, to give legal recognition to them. But then, with the passage of time, this act has been amended from time to time to include therein various kinds of offenses which are being committed with the help of technology, or which are committed against that computer resource itself. As I said, the act has evolved because the General Assembly of the United Nations in 1997 adopted the model on e-commerce, and since India was a party to that, India was bound to enact a law to give effect to the UN decisions. And there, since that resolution passed by the General Assembly recommended that all member states, which India was also a member, they should consider this model e-commerce law, and they should enact or make their laws so that this e-commerce laws can be incorporated in the laws of that country. And they thought that there is a need of having uniform laws dealing with e-commerce throughout the world, so that it is easier to identify. Is it visible now?
Yes, sir.
So, as I said, of course, the act can be divided into three parts. I will not deal with first two parts as such, because let me put it on record, it's a huge act. I'll only be discussing the portion which is relevant to us, and in as simple terms as possible. As I said, act can be divided into three parts. First part is dealing with administrative provisions, then it is dealing with civil provisions, civil penalties, and then with the criminal matters or the offenses which have been created, which are relevant for us. But there are a few important things which we need to understand at the beginning. It's a very complicated set of law, and many regulations have been made there under. And it is very difficult to comprehend, especially for an advocate who might not have that much information about hashing, about crypto functions and all that. But I'll try to explain it as to the extent possible. Before I go further, let us understand that, as I said, this act was enacted to provide legal recognition to electronic records. And if you see, in 2023, Bharatiya Sakshya Adhiniyam 2023 in section 61 has specifically declared that the electronic records, electronic documents shall be at par with the offline or the paper documents. This is for the first time that we have declared in India that the electronic documents as are dealt with by the Information Technology Act. Those electronic documents may be emails, those electronic documents may be e-contracts, e-MOUs, or maybe the message contained in a WhatsApp. All those electronic documents have been declared to be at par with the traditional paper documents and are admissible in courts. So we have come a long way from 2000 just to legally recognize electronic records to 2023 Act, that is Bharatiya Sakshya Adhiniyam, implemented from 2024, that electronic documents, electronic records, they shall be at par with the traditional paper documents in a court of law for all purposes. So, say this section 4 of this act basically declares, as I said, as to what are legal recognition. Now, coming to the more important portion, which affects us. Now, if someone, let us suppose I have an employee or I have a student, I give him my laptop and I say, okay, fine, you can read this paper, this document from my laptop. But what he does is he accesses internet and he accesses the other files contained in the computer. So the question would be, is he committing a crime or is he liable for a civil penalty? So section 43 deals with this kind of a scenario. It says anyone who without the permission of the owner of that computer or computer resource, he secures access to. I have given that student access to only one document, one PPT, but now he's searching my laptop, my mobile without my permission. So anyone who without the permission of the owner gains access to a computer, secures access to a computer, or disrupts access to the computer or computer resource, or anybody who is downloading secretively without my permission, copying files, extracting data from my computer, or he is putting any viruses, any trojan into my computer resource, or any other contaminant. So, or he is changing any content in a file, modifying, rearranging, deleting, altering, destroying, or changing the file format, damaging the computer resource. All these things, this long list of actions which are specified in section 43, that person would be deemed liable to pay penalty, to pay compensation, as may be decided by the adjudicating authority. Before the amendment of section 43 in 2009 and 2017, the maximum amount of penalty provided was 1 crore rupees. Now there is no such ceiling, and the adjudicating authority or the appellate authority can impose any penalty on the person depending upon the nature of harm caused. They can impose penalty on the person who has done these acts, civil wrongs, torts as we call them, and they will be required to pay compensation to the extent as may be determined by the adjudicating authority under the Information Technology Act. Of course, that order would be appealable. One can, but then civil courts have no jurisdiction. The party affected cannot go to the civil court. They can only approach the appellate authority, which is the notified one, that is TDSAT, Telecom Dispute Settlement Appellate Authority. They can only approach the TDSAT and can make an appeal against that, and the decision of the TDSAT shall be final, subject of course with an appeal to the High Court. But then they cannot approach the normal civil courts. So the fact of the matter is, somebody's computer or computer resource gaining unauthorized access thereto is a civil wrong, as well as if the computer is hacked, that would be a crime also. We will discuss that little later. Similarly, section 43A of the Information Technology Act, it casts an obligation on every company, every body corporate who is dealing with sensitive personal data or any information which is stored in a computer resource. If that that body corporate does not secure that data or does not comply with SPDI rules, that is sensitive personal data rules of 2011 and reasonable security practices rules of 2021, enacted by the government or certain, then these body corporates, these companies who are processing that data, dealing with that data, and if they are found to be negligent, they would be liable to pay compensation to the person who is affected by the breach of this data. Again, you see, if you see the IT Act and its regulatory regime, you will find that India has basically two-pronged setup. One, so far as the critical information infrastructure is concerned, CII, critical information infrastructure. So this critical information infrastructure includes the power sector, energy sector, banking sector, transport sector, government services sector. So that is critical information infrastructure. So if so far as CII is concerned, we have established a nodal agency in the form of National Critical Information Infrastructure Prevention Team. So that NIIPC, that cell, that is National Critical Information Infrastructure Prevention Cell, that looks after all breaches, all of data, all damage of all unauthorized access to critical information infrastructure. And whereas the non-critical information infrastructure is concerned, for that we have this certain, that is Cyber Emergency Response Team of India. So that is where we call it certain Cyber Emergency Response Team of India. So certain has prescribed various rules regarding this reasonable security practices, which are to be followed by the body corporates who are possessing, who are dealing with the data, whether they are Amazon or whether they are personal, dealing with sensitive personal data, any other banks, for example. So they, for them, we have prescribed special rules, and if those companies, those body corporates are negligent in adhering to those rules, and because of that some data breach takes place, for example, as I referred to Air India, in 2021 4.5 million people data was leaked, and therefore those companies can be held liable to pay compensation under 43A. Rather, if you see the certain 2022 rules which have been notified just 3 years ago, they have made it mandatory that whenever there is critical information infrastructure breach, within 6 hours that is required to be reported to the nodal agencies within 6 hours. And the persons affected thereby are also required to be informed that there's a breach in data. So now we are moving towards a very sophisticated system of managing the cyberspace, regulating the cyberspace. This apart, we have updated the law and now we are imposing heavy penalties if there is a breach, civil breaches of data. For example, those entities, those body corporates which are required to furnish information or returns, if they do not furnish, fine up to 15 lakh can be imposed on them. If there's a delay in furnishing the information, then fine of 50,000 per day, not exceeding 50,000 per day, can be imposed on them. And for any breach of data for which no penalty is prescribed, Section 45 says that 1 lakh rupees fine plus compensation which can go up to 10 lakh rupees, that can be imposed by the adjudicatory authority. As I said, adjudicatory authority, that is the officer appointed under the Information Technology Act. And similarly, if there's a failure to maintain records, failure to preserve those records, then fine which can extend up to 1 lakh per day can be imposed. So point why I'm telling this is, huge, very stringent measures are taken by the Indian legislature in ensuring the data security. We of course understand that there are millions of data breaches every year across the globe, yet the legislature is trying to bring in as much stringent provisions to avoid this. That is the civil aspect of the law. I have just rushed through it so that I can come to the criminal aspect of this. As we understand, there are various cyber crimes. When we say cyber crime, that means it's a crime which is committed ordinarily against a computer resource. Computer has been defined very widely. If you see section 2D of the Information Technology Act, computer resource, computer applications, mobile, computer network, all these have been defined very widely in the Information Technology Act. So cyber crime, we usually mean the crimes committed with the help of computer resources, with the help of mobiles, with the help of internet. But then we also understand that computers are not only the weapons of crime, but they are also the victims of crime. So there are various types of cyber crimes. I have just tried to make an illustrative list. These days we are talking about digital arrest quite a lot. Many instances of digital arrest have surfaced where the people are being called because there is a data breach somewhere. If I have approached some seen a website and there's a data breach from that website and that data has been leaked to the fraudsters, to the scamsters, and they are misusing that data. They are calling us and they are saying, in your parcel this thing is found and therefore we are calling from such and such place. There are cases when crores of rupees are siphoned off and people are kept in digital arrest for 24 hours or more than that. So that is how the cyber crime incidence is increasing day by day. Cyber terrorism, we all understand. Cyber snooping or cyber spying. So again, cyber snooping is another kind of an offense which has become. These days, some governments across the globe, Israel has been accused that they are using cyber snooping. They are using certain softwares which are being uploaded in the mobile devices, and therefore they are able to do spying of the important persons whom they believe the information should reach them. Indian government has also been accused of using a particular software from Israel for the purposes of cyber snooping or whatever purposes. These are accusations. I'm not saying they are correct. So there are many. Cyber stalking is another offense when a person is not following another person physically, but in the online. Wherever you visit that person, you'll see that person on your screen. The person is consistently following you at various places. Cyber defamation, whether this is Facebook or social media, the people are defaming others without bothering that this constitutes a criminal offense for which the person can be prosecuted. Cyber harassment, cyberbullying, spamming, sextortion. There are various offenses. The list is pretty long. Sexting, these hacking, we all understand. We have specifically included provisions in section 65 and 66 for preventing hacking. SIM swap scam, when somebody gains access to the SIM data and gets duplicate SIM issued, eSIM issued in your name, and therefore he using that eSIM for various criminal activities. Malwares are being installed in computers, in mobiles. SMS spoofing, email spoofing, online pornography, identity theft. That is very important when somebody's identity is stolen using the IT information techniques. I'm not explaining the meaning of these offenses. Viruses, worms, online drug trafficking. The other day, yesterday only, I spoke to that people are using the online resources for drug trafficking, for purchasing drugs. I gave the example when the Swiss ransomware that Humana used purchased drugs online from the dark web. Breach of privacy. There are, as I said, the list is endless. You can see from the slides that online gambling. Some students are also resorting to online gambling. DoD attacks or denial of service attacks. These are very serious attacks on denial of service attacks, where the server of the service provider is spoofed. There, that is spammed in such a manner that the service provider is unable to provide the service. For example, banking services, and causing losses to the tunes of millions of rupees. Salami slicing, very small. I mean, you are rounding off 90 rupees and 15 paisa, you are making it 91. Very small portions of financial fraud. But then, if you have millions of transactions, it can become a huge amount. Crypto jacking, fine. You are the committing offenses in relation to cryptocurrencies. So all these offenses are being committed with the help of computers. Now let us suppose there is an intermediary. Intermediary is a person. I'm specifically not showing this slide. I'm just willing to discuss. There are liabilities of the intermediaries. Intermediaries are like Amazon, like Flipkart. Those who are not expected to those who are not expected to, I mean, intervene. They are just facilitating the third parties to sell their products, to post information, to offer make offers on their platform, and whatever information is put by them, by the third party on their platform, the intermediary is not changing it. He does not control it. Generally, that's what we mean by intermediary. If we see section 79, that was section 2 of the Information Technology Act. Now, let us suppose on Amazon, some person is selling pirated products, or the person is using the trademark of some other person. Do you think it commits a crime? He has committed a crime. Can that be taken care of? Can Amazon be fined because a third person is using the Amazon platform and selling the counterfeit products? Let us suppose USPA. So he's saying this is a USPA product, and he's also using the trademark or the logo of the USPA or any other brand which you feel. Do you think it is the offense committed by that third party, or whether the Amazon or Flipkart or Myntra, for that matter, they can also be prosecuted for that? Yes, anyone, because otherwise it is becoming more of a pravachna. Yes, please.
So we can take questions at the end.
I'm just trying to engage.
Okay, sir. Okay.
Otherwise, I can keep on explaining the slides if you wish that. That way, I don't have any issues. Great. Wonderful.
I think third party will be responsible only
Why not Amazon?
because Amazon has just provided the platform.
Okay, great. There are two things. One, that now we have got 2011 rules, intermediary rules as amended in 2018. Under the Information Technology Act, we have, yes, there's a safe harbor clause. Safe harbor clause we mean that intermediary generally is not liable, because on only when intermediary satisfies certain conditions, which are of course specified in section 79. I'll not go into that technical details, but then for a layman, if the intermediary does not exercise control on what content is posted, but it is the liability of the intermediary to notify the persons who are posting on their website regularly that they should not violate any, they should give an undertaking that they do not violate any law in force, and that they comply with the legal requirements. It is his responsibility, and it is also the responsibility to ensure that once the problem or once the crime is brought to the knowledge of the Amazon or Flipkart or any other intermediary, then they take remedial actions as soon as possible. So if they are not exercising any control, and they are informing the clients, the persons who are posting in the website, that they are under obligation to comply with the laws, and that they should not infringe any copyright or trademark, so then they can avoid the liability. But then Amazon has not been treated only as a intermediary these days. If you see in February 2025, this question arose before the Delhi High Court. And Delhi High Court in its February 2025 judgment, Beverly Hills Lifestyle Services, which have a brand name of Beverly Hills, who are selling lifestyle products, their brand name was being misused. I'll show you how that was misused. Give me 1 second. If you can see this on your screen. So, Beverly Hills Polo Club, their brand, their trademark, their mark was used by a company in India, and they were selling the products on the Amazon. Beverly Hills, they filed a suit against Amazon in Delhi High Court and got the Amazon was held liable by the Delhi High Court, and some amount of 336 crores as penalty was imposed on the Amazon, because Amazon, they said, is not only intermediary, they were aware that duplicate marks were being used. See, it is not only a cyber crime, but it is also a fraud with the consumer. Consumer is trusting the Amazon and buying a product, and he's believing that this product is original. But then the product turns out to be a fake one, to be a copied one, and therefore under the Consumer Protection Act as well as under the Information Technology Act, the Amazon was held liable by the Delhi High Court and was imposed a penalty of 338 or 36 odd crores because they have committed the offense. They said Amazon was liable. So therefore, we need to understand that when this kind of forgery is being committed online with the help of computer resources, we have the remedies under the Indian law. Yes, it is difficult to prove, but still the bigger company, the Beverly Hills Polo Club, they were able to prove that against Amazon. And of course, Amazon has filed an appeal in the Supreme Court, which is pending. I just wanted to engage. Anyways, coming back to the offenses. Okay, if you see sections 65 to 72 of Information Technology Act, various offenses have been prescribed. 65, and now in 2019 and 2023, the punishment for these offenses has been made very, very stringent. For example, if you see section 65, now section 65 provides that if anyone tampers with the computers, computer source code, computer programs, computer systems, computer network systems, anyone, that has been declared as an offense and which is punishable with imprisonment, which can go up to 3 years, or the person can be fined up to 2 lakh rupees, or punishment as well as fine, both can be imposed on a person. If you see section 66, which has made hacking as a punishable offense. Section 66 declares hacking as a punishable offense, and section 43 makes that as civil wrong. So section 66 and 65 both read together, they say if anyone gets illegal access to computers, or anyone downloads the data, copies the data, or puts any virus in the computer, or any other thing which is mentioned in that section, or maybe denial of access to computer, then section 65 read with section 66 makes hacking as a punishable crime, which can be imprisoned up to 3 years imprisonment, or with fine, which can extend up to 5 lakhs under section 66. We need to remember that hacking could have been dealt with under the traditional criminal law also. Under the Indian Penal Code or its successor, Bharatiya Nyaya Sanhita, before the advent of the Information Technology Act, hacking was treated as a theft, because if you see 378 of IPC or 303 of the Bharatiya Nyaya Sanhita, data is a movable property. So since data is considered as a movable property, so anyone stealing that property could have been and can still be punished not only under the Information Technology Act, but also under Section 303 of the Bharatiya Nyaya Sanhita. Similarly, if you see Section 314 of the Nyaya Sanhita, which deals with misappropriation of property, the offense of hacking can be correlated with that, as well as with 318, that is fraud. So anyone who uses the computer for stealing the information, for concealing the information, or maybe for the purposes of fraudulently downloading the data, copying the data, or maybe if somebody is copying or tampering with the computer programs, these are serious offenses under the Information Technology Act. This apart, if you see Section 66B, Section 66A has been omitted in 2023 because of the judgment of the Supreme Court in Shreya Singhal versus Union of India. What happened was that Section 66A makes that somebody puts some offensive messages on the online platforms, on the social media, which incites some enmity, which incites violence, that was declared as a crime. But what happened is that in Maharashtra, some Shreya Singhal posted certain posts on the Facebook where she objected to that why this band is being called on the death of some important political leader. And since that leader's party was in power, what they did is she was booked under Section 66A of the Information Technology Act, and she filed a petition that, see, this is violation of freedom of speech and expression. I have a right to post my views on the Facebook or on any other social media. It is not offensive. I have only questioned the rationale why this kind of band is being called when some political leader dies, and why all these services are put to a halt. And therefore, the Supreme Court said this section of Information Technology Act is constituting a violation of the freedom of speech and expression, which is a fundamental right under the Constitution. So going by the Supreme Court decision in 2023, Indian legislature has omitted Section 66A from the statute book. Now, if you see 66B, 66C, 66C, I have already referred to identity theft. So if somebody uses electronic signatures, copies electronic signatures, electronic password, or any other unique identification features, as we understand that these days, many documents which are required to be filed with the government are required to be filed with the help of electronic signatures. For example, ITRs, income tax returns, we file them with electronic signature with eKYC or Aadhaar-based OTP. If somebody steals that information, that is by electronic signature, it is a serious offense which is punishable with imprisonment, which can go up to 3 years, and also with fine which can extend up to 1 lakh rupees. And then if somebody receives a computer resource which is stolen, or a mobile device or a tab or any other communication device which is stolen, so that is also an offense punishable with the same imprisonment. Impersonation. Many times we receive phone calls and they say, okay, fine, I'm speaking so and so. They impersonate somebody else, and accordingly many times what happens is you receive an email. It has happened with many of us. You receive an email which you believe is from a person known to you. His photo is being used on the WhatsApp or on the email, and you believe that it is his email, and he says, I am sitting in a mobile shop, or I am sitting such and such place, I need urgent money. He's impersonating somebody else who is known to you, because he knows that you are known to that person, and if that person is in need, you would pay the money immediately. And therefore Section 66 provides that if somebody is impersonating using a computer resource, that is also an offense punishable with imprisonment, which can extend up to 3 years. We have already discussed yesterday that right to privacy is a fundamental right now, and if somebody uses this, breaches the privacy, captures photographs of private area of a person, publishes photographs, transmits photographs or images or videos on whatever social media or the electronic media, without the consent of that person, that is serious violation of privacy. Of course, fine compensation can be imposed upon the person, but also that person can be imprisoned up to 3 years, or fine of rupees 2 lakh can be imposed upon him, or even the court can imprison the person and also impose the fine. This apart, if you see DOD attacks, denial of service attacks, as we discussed that many critical information infrastructure, they are being spoofed in a manner that they are unable to provide the service, which is dealt with by section 66F, which also deals with cyber terrorism. So if it is critical infrastructure, maybe transport, maybe the airline, maybe the airport authority of India, energy sector, banking sector. So if it is critical information infrastructure, which is the where the servers are flooded with the or network is flooded with excessive requests, so that you are unable to provide the service, that would tantamount to cyber terrorism under 66F, which is punishable with imprisonment, which can extend up to life imprisonment. Similarly, section 67C also talks about that penalties can be imposed for denial of service attacks. So if you see, cutting short all these offenses, so if some material we understand in India, section 67B is very important. In India, child pornography is an offense. Not only child pornography is an offense, but anyone who watches child pornography, who transmits child pornography, that is also an offense. So what happens these days is what we call as extortion or sextortion many a time, that they will make a video call to you. Since our front mobile camera, we get a video call on WhatsApp and we immediately pick it up. Many a time people do pick up, and then they'll show on the screen some child pornography and take pictures on the screen, and then they will ask you that since you were watching child pornography, you have committed an offense under the Information Technology Act, and therefore you can be imprisoned with the sentence of up to 5 years, and also fine can be imposed upon you of 10 lakh rupees. We are going to share these pictures with the police walas, with the jurisdictional police station, and therefore they ask you to pay ransom. They ask you to pay extortion money. So because section 67B makes it a punishable offense that anyone who publishes, anyone who transmits child pornography, or who facilitates the abuse of children, or who browses, downloads, promotes, advertises such material, or even transmits that on the WhatsApp, or who induces children to come to an online relationships, he commits a very serious offense under 67B. And if that person is caught again, then he can be punished with enhanced punishment, which can go up to 7 years of imprisonment, and also with fine, which can extend up to 10 years. So, as I said, that there are various offenses which have been, created under the Information Technology Act. But the point is, I just said that, see, there are two more important things which I need to tell, then I'll move on to another section. The government has been empowered, that government can ask any entity to collect data, to collect traffic on a particular ISP, to monitor data, so that the government is able to protect the sovereignty and integrity of the country. And therefore, if the government is authorized or government has asked data from a particular establishment, and they do not collect and monitor data or information from any for cybersecurity which is demanded by the government, that has also been declared as an offense. Now we also need to remember that government has the power to block internet. Of course, they are required to record the reasons, and reasons are required to be reasonable. The Supreme Court of India has already declared in Anuradha Bhasin that right to internet is a fundamental right. being part of the freedom of speech and expression. But each fundamental right can be subject to reasonable restrictions which may be imposed by the government, and therefore when the government believes that the security is in danger or maybe there is safety law and order issues, government can block internet, and India is one of those countries where internet has been blocked many times. This apart, yesterday we referred to Digital Personal Data Protection Act. Digital Personal Data Protection Act has also created and has also defined various breaches of data and which have been made punishable with imposition of damages which can extend up to 200 crore of rupees. If you see your screens, you'll find that those data fiduciaries, that means those companies, those organizations which are handling our personal sensitive data, if they do not comply with the obligations, if they do not take reasonable security practices which are mandated, as I said, under 2021 rules, then they can be punished. They can be punished with imposition of penalty which can extend even up to 250 crore rupees. So if you see the various breaches which those data fiduciaries, those companies, those entities which are handling our personal sensitive data, if they are committing those breaches, then the Digital Personal Data Protection Act 2023 is making those data breaches punishable with imposition of penalties which can extend to 200 crores or 300 crores or even up to 10,000 crores rupees. Point why I'm telling is, but then before I move further, let me share another information. As I told yesterday, the DPDP Act has not been fully implemented. The government has only notified the rules, and government is talking to the stakeholders so that how can we improve those rules. So for the time being, Digital Personal Data Protection Act, though it has received the assent of the president on 11th August 2023, yet the law has not been fully enforced. Now coming to the more important part, and here I would engage into discussions rather than giving a lecture. When a cyber crime is committed with any one of us, I have also been the victim of cyber crime. Fortunately, I was safe. When I accessed HPDDC website, Himachal Pradesh Tourism Development Corporation website, booked a hotel of HPDDC, and my credit card data was stolen overnight, and some transactions were made abroad. They were very small transactions which did not require any OTP. Total amount of transactions was around 10,000 rupees. But then I immediately blogged and approached right in the morning when I got up. I approached the ICICI Bank and I told them that these are the transactions which are unauthorized, which have taken place, and finally I got the money back. Anyways, the point why I'm sharing this is that cyber crime can take place with anyone. Recently, one of my acquaintances invested money through a Telegram channel. She got on the Telegram channel certain recommendations, and she used those recommendations, made use of those recommendations, and then started gaining certain amounts, answering questions, getting amount, and then she started investing on the recommendations of the Telegram channel, and finally she lost around 6 lakh rupees in that entire gambit, of which kept on going for 3 or 4 months, and in the end she wanted to launch a complaint. So the question is, when that cyber crime is happening, what should we do? Where should we go? Now when we tried to investigate, cyber cell, they said it is not Indian but then somewhere outside. So now what are the jurisdictional issues? Can courts in India try the offenses? Can they give decision when the matter has taken place, when the persons are outside? That is where the next portion of the presentation belongs to. If you see Bharatiya Nyaya Sanhita section 1 subsection 4 and section 75 of Information Technology Act, if any offense is committed whether in India or whether from outside India, but when the target is a computer resource in India or a mobile in India, Indian courts have the jurisdiction to try that offense. Indian police can record that offense, and as we understand, the government of India has issued 1930 as the online cyber crime reporting number. So anyone can call at 1930. Cybercrime.gov.in is the government website on which people can lodge complaints. Cybervolunteer.mha Ministry of Home Affairs.gov.in is another website which the government has launched, where we can track the status of our complaints and we can upload the data. Cyber Swachhta Kendras have been established by the government of India. So the government of India has facilitated that if some cyber crime is committed, we should report it immediately to the and then we in states, the police departments have established cyber cells which are there to investigate the offenses. Let me share an anecdote with you. Some 12 years back, 13 years back, a friend, an acquaintance of my friend, he received an email containing abuses, huge list of abuses running into several pages, 8 or 9 pages. Not even a single abuse was repeated. So he was a little unhappy, of course. One would be if the person receives bag full of abuses from an anonymous email ID. So he complained to the cyber cell at Delhi because the person was in Delhi. Nothing was done. I'm talking of 2012, because the cyber crimes, of course, they were being committed, but then it was not very popular for the police to address them. So again, next month on 1st, he received the same kind of an email from a different number, different email ID. So it happened for 3 continuous months that he was receiving on 1st of every month the complaints, the letter containing handful of abuses running into, 7-8 pages, not even a single abuse repeated. So he was very, very furious. We all went there, and my friend said that his acquaintance is getting this. We started investigating. We approached the cyber cell. We had few friends there. And finally, we got hold of a person who was sending these emails. So now, what are the jurisdictional issues where we can approach? As I said, you can approach 1930. We also approached 1930, got a complaint registered. We went to the cyber cell. And then, as we understand, under the Information Technology Act, any police officer not below the rank of an inspector can investigate the offense. And if the offense is a serious offense, which is punishable with imprisonment of 3 years or more, then he can record an FIR straight away and start investigation under the Bharatiya Nagrik Suraksha Sanhita today. He can, if he is able to identify the computer resource, as I said, we got hold of cyber cell. They were able to identify the IP address, and IP address was traced to a bank, to a private bank in Noida, in Gurgaon. And then from that bank, we were able to trace which computer resource was being used by that banker for the purpose of sending that email. And finally, we got hold of that girl who was sending those offensive letters, emails. Because the police has been given investigation powers under the Information Technology Act, that if it's a serious offense, they can record an FIR, they can investigate it, and once they are able to identify the crime scene, they have the power to proceed to that crime scene, a certain facts and circumstances, collect digital evidence. Now, how do you collect digital evidence, and what is evidence in the given matter? Let us suppose the evidence is contained in the WhatsApp. Whether WhatsApp chat is an evidence? Yes, please. Anyone? Whether WhatsApp chat is an evidence? Can that be of law?
Yes, sir.
How would we produce WhatsApp chat as evidence in court? Yes,
Sir,
it
can
can
be
be clocked,
done
of
in form
course.
of screenshot or download? We can.
See, when we talk about Sakshya or Sakshya, the name of evidence in India, we say best evidence should be given. Best evidence is the original one. Where is the original one? That is contained in your mobile device, on your computer resource. So how would the court understand that this is the original one and therefore it has been genuinely sent by someone? So what is the procedure therefore? That is where Bharatiya Sakshya Adhiniyam section 63 comes in handy. Section 63 of Sakshya Adhiniyam says that whenever you are giving digital evidence, you will obtain a certificate. You will obtain a certificate from the person in charge of that device, that communication device, that computer, or that tab, or that personal assistant, as the case may be, whatever is the device. And then an expert should also give a certificate, as mentioned in section 63, giving the hash value that when I took this evidence from the computer resource or from that device, when I copied it therefrom, this was the hash value. You understand? I mean, those who are belonging to those who are from the computer background, they will understand how the hash value is created. You can use various tools, online applications. FTK Manager is one. NCase is another. You can use those tools, find out the hash value, and therefore the owner of the device will give a certificate. And this all of us. If I am having a CCTV and some crime is committed outside, police will ask me to give the CCTV recording. Not only CCTV recording, but also sign a certificate that data has not been tampered with, data has not been manipulated, has not been deleted. So, and also to give a hash value certificate, mentioning on that certificate, this is the hash value when the data has been transferred. So when that data is being played again in the court, you will check the hash value. If the hash value is same, then that means data has not been tampered with. If the hash value has changed, that means the data has been tampered with. Even if you add some comma, some space, the hash value would change. Anyways, so if the evidence is contained in computer resource, somebody has used the computer resource to do some fraud, to do some transaction, then of course the data is contained in that computer, that laptop, or that mobile. Can the police ask you to furnish your password of that mobile or that computer resource, as the case may be, or tab? Can they ask the person to give your password? And are we bound to give the password if we are accused of an offense?
Sir, I think if we are accused, we are bound. Otherwise, depend upon your privacy. If you want to give up.
See, Constitution of India, Article 20, Clause 3, that says, no person accused of an offense shall be compelled to be a witness against himself. So Article 20, Clause 3 says, no person who is accused of an offense shall be compelled to be a witness against himself. Yes, Urshi madam has said, yes, they can demand the password. Of course, they can demand. That is their right to demand. And then it is for us to decide whether to give or not. But then there are judgments where the court has said, for example, if you see Virender Khanna 2021, the Karnataka High Court has said that when the police demands the password from the accused, from the person accused of an offense, he is bound to supply that password. And if the person does not supply, then what will happen? The person may refuse to supply. He may say, okay, I'm not willing to supply the password, and I don't want to. Can you compel him? Even if you use third degree, the person is very, very rigid. He is not willing to give the password. Then what to do? The entire data, the entire evidence would be contained in that computer, that laptop, personal assistant, tab, mobile, as the case may be. Then only you prove that he has committed some offense. So how would you assess that data if the person is not providing the password? As I said, in 2021, the Karnataka High Court in Virender Khanna said that what would happen If a person is traveling on a road on a vehicle and you find and you suspect that he has got some drugs with him, can you search his car, his bags, or can you conduct a personal search? Answer: yes. Under the NDPS Act, the police officer, when he receives an information that someone is carrying drugs, they can conduct a search of that vehicle. We see the police stopping the vehicles on the way and conducting personal search of the vehicle. They said in the same vein, if the police can conduct a personal search of the vehicle, why can't they conduct the search of a computer or a mobile or any other computer resource? And if the police ask that person to give his password and the person refuses to give the password, the police can use the services of an ethical hacker to hack into the system, get the data therefrom, use that data as an evidence. So police can use the services of professional hacker and can get access to the data. And if the professional hacker is also not able to get into that computer resource and is unable to access the data, then the court said you can use it as an adverse inference. Adverse inference, we say that the person who has refused to give the data, it is assumed that the information must be against him. And therefore, we say that we presume that he has committed some sort of a crime. So if you see, though this decision of the Karnataka High Court of 2021 is debatable because Delhi High Court has given an entirely different decision, and now the matter is before the Honorable Supreme Court of India, which is considering this matter. But then the point is that police can ask, once they are conducting the investigation, they can ask for the evidence, and they can, if the digital evidence is with you, they will ask for a certificate from you. You can see on the screen. They can ask a certificate to be filled by the party who is in charge of that device, that mobile, that flash drive, that computer, CD, server, cloud, DVR, whatever. To mention therein the name, the make, the model, the serial number, and also, as I said, the hash value of that device. So hash value would be computed. You also have to mention therein by which resource, which method you have computed the hash value. Have you computed the hash value using Message Digest 5 app, or maybe secured hash algorithm 256? So what method you used for computing the hash value, that is also required to be mentioned. And this certificate is also required to be signed by an expert. Is required to be signed by an expert. Expert will also mention that, okay, fine, this is the device. And now you also should understand that you are giving the certificate that my device was working properly. If it's a WhatsApp message and you give that evidence that you are giving the certificate, then you also have to say that this was it was in my possession, what is the make, what is the model, that this device was working properly, the information was fed properly, and that it was maintained properly and it was working properly. You also mentioned this. So you can, the court will also ask the report from the expert. If I glance through the cases filed in courts regarding computer related crimes or cyber crimes, in a computer resource, the electronic evidence can be found in various places. It can be found in email messages, office files, or deleted files, encrypted files, temp files, recycle bin, pictures, the metadata of the pictures, web history, cache files, cookies. There are multiple places where electronic data can be found. So when the electronic data, electronic evidence is found in a cybercrime matter, then the police will ask you, either they will seize that computer. As I said, the court said that in Virender Khanna, that these computer resources can be seized like any other, like you seize the drugs or any other thing. You can also seize the computer resource. You can seize the mobile. The police has those powers. And the court said that whatever files are open, you should not close those files. The police officer should not close those files. They gave very detailed guidelines. If you see on your screen, Virinder Khanna versus State of Karnataka, that and then they said these devices should not be switched on. The mobile or maybe the laptop, it should not be switched on. It should be preserved in a manner. Okay, 852. So it should be preserved in a manner in those Faraday bags, as we call them, so that nobody is able to tinker it from the outside. For example, these are the Faraday bags in which these kind of devices are to be stored, because then they prevent any magnetic or any outside interference with the computer devices using remote access, etc. So the point why I'm raising this is, I'm skipping almost 10 slides because we only have a few minutes left. Because the law is still developing. If you see the number of cyber crimes which are reported as per the National Crime Record Bureau, crimes, I'm not saying cyber security threats. Cyber security threats are in lakhs. If you see Cybercrime Portal of India, cybercrime.gov.in, the number of cybersecurity threats, they are in lakhs. I'm talking about the FIRs which are registered. So you see the trajectory in the last 12 years. From 1,322 to 2022, we find that it has reached to almost 66,000. So number of cyber crimes which are being recorded by the investigation agencies, where the FIR has been recorded, that has grown, I mean, tremendously. If you see from 2021 to 2022 itself, the increase is by more than 22%. So having said that, we also find that there are many issues so far as these cyber crimes are concerned, so far as the cyberspace is concerned. But one more point I want to bring in before I wind up my discourse. I'm continuously seeing the watch. I was glancing through the data, and I found that when we talk about the regulation of cyberspace, we also need to be aware of that this cyber revolution, this digital revolution, we say digital India, we should make digital India. How much it is contributing to pollution. So here I would quote UNCTD Digital Economy Report of 2024, which shows that the computer-related or the mobile-related waste is increasing day by day. 30% increase of IT equipment which are going in waste, which waste has to be disposed of. That has increased by 30% in the last 12 years, from 2010 to 2022, reaching almost 10.5 million tons. Disposal of this much of IT waste is a humongous task. And if it is improperly disposed, it poses serious environmental hazards. As we understand that not only the computers and mobiles, but also these days, due to 5G, 6G, mobile networks, IoT, so therefore the emissions which ICT is raising. So if you see that also, so ICT sector emitted an estimated 0.69 to 1.6 gigatons of carbon dioxide in 2020, which corresponds to almost 3.2% of the greenhouse gases emissions. So therefore, we also need to remember that with the increasing digitalization, it is not only the regulation of the cyberspace, but it is also the regulation of the waste generated by the cyberspace. From my side, that is it. Now we can take questions. Yes, please.
Thank you very much, sir, for another enlightening talk. We enjoyed the talks yesterday also, and it was another addition to your excellence. And we need to do two important tasks. We can have the opportunity to ask the question to the speaker. And sir, if somebody has written the questions in the chat box, we can go through.
Give me a minute.
Or otherwise, sir, I have a question. You pinpointed on a very important aspect today, that is called the digital arrest. And I think this is really creating havoc among many societies, especially among the elders, and also the people who are not very much literate about the computer, IT, and other things. So how government is handling this thing? And second question is like that. Uh, these criminals are also following our social patterns and other things. Is it possible that before they follow us, the government agencies and other defense systems can catch them, before they create some serious issues to the normal society? Is something happening in this direction?
Yes, let me inform you that Government of India is trying to bring in two more acts because we believe that Information Technology Act 2000 is outdated. So now we are going to bring in Digital India Act, probably in 2025 itself. And that act will be far more superior, putting far more responsibilities on the service providers like websites like Amazon's or Google or search engines which we are using, where our data is going. Number one, data localization is what we are working at. And number two, we are mandating all these organizations. See, as I said, in 2021 and 22, we have brought in new rules for reasonable security practices while handling, especially while handling personal sensitive data. So now, once the DPDP Act, Digital Personal Data Protection Act, is notified to be fully effective, and plus once the Digital India Act is also brought in, we are also bringing in, sorry, one more act, Disha, which is for healthcare industry. That means secured healthcare industry. So if these three laws, once they are brought in and they are I mean implemented in tandem, it will provide a very I won't say foolproof, but it will provide a very stringent security cover where we can of course prevent such kind of attacks. This apart, one more thing which I must put on record: government has been authorized, the state as well as center, by the Information Technology Act, that they can ask the service providers to monitor the data, monitor the traffic. And if they find that the traffic on a particular IP that is being used for committing some crimes, it is the right of the government to get that data. Unfortunately, the implementation is little tardy. The Because in case of cyber crimes also, the conviction rate is little less for various reasons. Jurisdictional issues are one, and then how do we give evidence in a criminal code is another. These are the issues, and that is why, though the government has come up with very good information security practices, reasonable security practices, yet they are yet to be implemented. I mean, they have not been properly implemented because of lack of awareness. They are, as I said, they have mandated that you report it to the cybercrime portal. Let me put it on record again. I told you that one of my colleagues, she is an associate professor in National Law University in southern part of India. She became victim of digital arrest. I mean, what to talk about those elderly and others? She did not inform anyone. It's only after she lost probably 6 lakh rupees that she came to know that this is all fake. Because what she did, she sent a parcel, and that data from that company was leaked out to the fraudsters. Probably one of their employees leaked that data. And therefore, they use that data that this is the parcel you have sent, this is the number. And then they also tracked her bank number, bank details, her ITR details using, the dark web. And finally, they were able to arrest her digitally and extract 6 lakh rupees from an associate professor, from a teacher. So
Oh my God.
and I mean that is the level of the cybercrime in India.
And sir, what was the outcome? Did she got something back
She
or
was
it
not
was
willing to file the complaint.
okay?
She was not willing to file the complaint. She said, what will happen? My entire family and the entire fraternity will say that, are you a fool? You are teaching in
Yeah.
a national law university, one of the premier national law universities in India in the south. And what will you tell the people? And she was so worried about her reputation that she did not file. And
Oh
there
my
would be
God.
many others.
Yeah.
There would be many
Many
others
goes
who don't come up.
unreported, sir. Many goes unreported, sir, like this also.
Yes, many, many.
Any other question?
So, as you said, government has right to block the internet. Is it for some public emergency or to avoid some nuisance, or can it be against some individual who has
No,
committed
it's
some
not against some
cybercrime?
individual. It is in cases when, for example, Article 370 is abolished. So what they did is they blocked the internet in the entire Jammu and Kashmir. When they believe that some law and order issue would be there in some part of the country, they'll block that internet. But now, after the decision of the Supreme Court in Anuradha Bhasin versus Union of India 2019, where the Supreme Court said right to internet is part of fundamental right, that is freedom of speech and expression. They said whenever you block the internet, number one, that order of the DC deputy commissioner, that order should be made available, and it should only for a reasonable time, and you have to give details when those internet blockages have been done, outages have been done, and that has to be notified and kept on record, and you have to give reasons why that is being blocked. So now the internet
Right.
blockage is restricted to an extent.
Right. I have one more question. Is there any law for WhatsApp crimes? People who are selling products on WhatsApp, fraud products.
So if there is a product which is a fraud, of course you can report it to. I also wanted to say there's M Kavach. If you see Cyber Swachhta Kendra, government has come up with Cyber Swachhta Kendra, and they are giving mobile Kavach. So you can give access and they can see your mobile also, that whether it contains some ransomware. That is one point. But so far as WhatsApp selling is concerned, if that selling violates any of the laws, for example, I told you Amazon was fined 336 crore rupees because somebody was selling, counterfeit products. So if somebody is selling fake products on WhatsApp, again it's an offense, and you can report that on cybercrime.gov.in. You can also report that to the cyber cell of the area in which you are located.
Right.
Sir, call
Thank you.
recording is an offense or not?
Without the consent of the person, it is an offense. But with his consent, you can.
So nobody takes the consent.
Yes, that is true.
Thank you, sir. As we all know, this cybersecurity is a very important topic in today's scenario, where we daily came to hear about cyber frauds. Today's session provide us valuable insight about this cyberspace regulation. Thank you, sir, for explaining this topic in a very simple way about various cyber laws, cyber crimes by citing suitable examples. On behalf of my organization and participants, I extend my gratitude to you, sir, for sparing your valuable time and sharing your expertise with us. Thank you, sir. Thank you so much.
Thank you so much.
Thank you, Dr. Shweta, for nicely handling the day 3 of our event. And special thanks to Urvashi ma'am for introducing such a nice speaker. Sir, I heard about you, but I'm really overwhelmed with the the way
Thank you,
you
Harpreet sir.
have given us so much knowledge about this important aspect of our life, which is going to affect us a lot in the future also. So I will request Urvashi ma'am to make some arrangement to invite sir personally to our college. Yeah.
Thank you so much.
Sure, sir.
Yeah, and thanks a lot to all the participants on behalf of Dr. Gagan and Dr. Seema, who has some urgent work right now. I extend my thanks to all the participants, all the speakers who have joined today. Both of the speakers were, very excellent today. And for the first speaker, we will start with tomorrow with a question answer session because he's also having the session tomorrow. So participants, I request you to be attentive and also, keep asking some questions. That's another way of learning and participating and making the sessions more lively. Thank you very much. Have a nice time. Good night. from Hans Raj Mahila Maha Vidyalaya, Jalandhar. Thank you very much.